Hello and welcome to Borderlines. I'm here today to do a short episode just going over the new home care worker immigration pilots that were recently announced by the Immigration Department to replace the previous home child care and home support worker pilots that expired in June 2024. And that shortly after that happened, we were told that we were going to get a replacement program soon thereafter, and it finally did drop on the 22nd of March. We had heard some rumors, some inklings of what the new program was going to look like prior to that, but then we finally got the ministerial instructions themselves on the 22nd of March. The program is set to open on the 31st of March, so not a lot of time for people to get themselves organized now that they know what the actual criteria are. So I'm going to race you through the ministerial instructions as they read now and to just provide some commentary on where I see some of the issues arising. Now, firstly, these ministerial instructions are similar to the prior ministerial instructions in the sense that they were created pursuant to Section 14.2 of the Act. I'm sorry, I'm on the wrong ones. They create two separate classes, one for home support workers and one for child care providers. And so as with the previous pilots, it's not possible any longer to have a combination of work experience in in both of the two different fields. The two are hived off as being very separate, and so you have to have one or the other. You have to commit to one line of work rather than the other, and then you're sort of stuck in that specific line for the rest of the duration of the program. Sorry, I'm just trying to share with the other. There we go. Okay, I think I got the right one now. Yes, here it is. Okay, so as I said, created by Section 14.1. Now, what it means that they're created under Section 14.1 of the Act is that by the provision Section 14.1, these classes are a maximum of 5 years in duration, and they also are limited in size to 2,750 applicants per year. So as I said, there are two separate classes, one for the child care workers and one for the home support workers. So I'll just go through one of the two. They're otherwise identical, except for the NOC codes that are indicated. So in the instance of the child care provider, it means any occupation that corresponds to NOC 4410 other than a foster parent, and that's the traditional caregiver NOC. So it's like nanny, child care worker, or group 42202, which is the NOC that's like the early child, childhood educators, but they specifically carved out early childhood educators, daycare teachers, or supervisors. So you could be like an aide in a kindergarten, for example, or you can work in a daycare setting, but you can't be a teacher. Which is distinct from any other caregiver program in the past. Typically, it was the case that if you were working as a preschool teacher, or even as an elementary or secondary school teacher. Less so secondary, but definitely as an elementary school teacher, way back to the live-in caregiver program, that was still considered relevant and directly related work experience. So that has changed now. What the program, as with the previous pilot programs, are designed only for applicants who are seeking to reside in a province other than Quebec. These programs are not, like, Quebec has not opted into these programs created by Ministerial Instruction, and therefore they have no application for people who are seeking to immigrate to Quebec. I have dealt with situations where people who have got their work experience in Quebec can demonstrate that they're actually intending to live outside of Quebec once they are granted permanent residency, and those have been successful. But until Quebec introduces a similar program through the MICC, then that is not currently available to people who wish to remain in Quebec. So with both classes, the program is divided into Stream A and Stream B. Stream A relates to workers who are, at the time of their application, residing in Canada. They've clarified in the policy documents that doesn't mean you are necessarily physically in Canada at the moment of application, but you do need to have Canada as your ordinary place of residence. So there's going to be some nuance around that, I'm assuming, but you would need to show that you have been living in Canada. You also need to be authorized to engage in full-time and non-seasonal work in Canada under the regulations, other than these subsections. So essentially, you can't be here as a business visitor. You can't be here as a student. It needs to be truly a full-time work permit that you are holding. It can be maintained status, but other than that, you do need to have hard status. Now, I'll diverge for a second because they have also created a separate public policy that is designed to allow a very small number of out-of-status caregivers, including those who are on visitor, who have visitor status in Canada, to apply, visitor status or are out of status to apply. The public policy is also available on the website, and there's an announcement about that as well, and I can include the links to those in the show notes. But again, it's a very small program. I think that they've set it to have only 140 applicants, and I don't know whether or not the duration of that is going to be the same as for the pilot, which is 5 years, or if this is just going to be a one-off opportunity at this point. But I imagine that the demand for that program is going to be far in excess of 140, and I think even Minister Miller acknowledged that in one of his speeches about this program. So the other thing is that the eligibility must be met on the day that the application is made and at the ending date of the processing. So this is a similar requirement to what we've seen in the past, that if the applicant were to fall out of status at some point during the processing of their application, that would be fatal to their application for permanent residency. So meaning that if somebody is here on a work permit and their work permit is going to expire, that they need to find a way to extend that status. Maybe by an LMIA-based work permit, which should still be available while they're in Canada on a work permit. Stream B is for applicants who are outside of Canada, but still meet the other eligibility requirements of the program. And so the other requirements of the program are language proficiency. So language proficiency requirements have gone down. Under the old programs, it was a CLB 5, and now it's gone down to a CLB 4. So the language test must be issued by one of the approved language test providers, as with other categories. Education must be either in the form of a Canadian educational credential or a foreign diploma, but it has to be accompanied by an equivalency assessment that is less than 5 years old. So going to the educational requirement, sorry, where is that? I thought it was up here. Okay, sorry. Where do they define the, I thought that was down here. I know that the requirement in terms of the education is a high school diploma. I'm just trying to figure out exactly where it says that. But in any event, I know that it's a high school diploma that they need, the equivalent to a Canadian high school diploma. So in this regard, I should just mention that that for certain jurisdictions, it has been pretty routine that that Canadian high school education, for example, in the Philippines is not considered to be equivalent to Canadian high school education. It's typically the case that you would need at least 1 or 2 years of post-secondary education in order to meet the Canadian secondary school requirement. And so in order for that to be achieved, you would need to get the ECA that shows that the years of post-secondary education were equivalent to a Canadian high school education. In terms of work experience, because this is the thing that I should have said from the outset is that this program differs from other caregiver programming in the sense that it is a direct to permanent residency program. So the way that it worked under all previous programs was that there was a period of time that the person would be admitted as a worker, and then they would earn their work experience requirements after they have actually come to Canada. And so in this category, it's the opposite, that they actually must have their qualifying work experience prior to making their application. And then if their application is accepted, they would come to Canada, or they would be approved immediately if they're applying in Canada as a permanent resident from the outset. So the work experience requirements are that they must have acquired their work experience over a continuous period of at least 6 months of full-time work in an eligible occupation. So the eligible occupation would be either the childcare or as the home support work, with the limitations that I've mentioned previously, that it can't be as a teacher or it can't be as a foster parent, but it needs to be full-time work. It must have been acquired within 3 years before the day on which the application was made, and it must include the performance of the actions described in the lead statement, including a substantial number of the main duties for the occupation. If that work was in Canada, it must have been acquired while the applicant was authorized to work under the regulations and had temporary status. Now, again, for this subsection E, there is the pilot does actually, the public policy that deals with out of status applicants also has an exception for people who were not authorized to maintain to get their qualifying work experience. So again, for that group, that smaller group of 140, that is possible. But there are certain exceptions that the work experience cannot be sought, cannot be accrued before the person reached the age of 18. It cannot be done in a period of self-employment, and it cannot be done while the person was engaged in full-time study, which is, in this definition, at least 15 years of instruction per week during the academic year. There is an alternative that even if there is no work experience in the field, there is the possibility of qualifying for the program based on training alone. But the training criteria is quite specific. The training must have been undertaken primarily in an in-person classroom environment and have been acquired through full-time study, meaning at least 15 hours of instruction per week during the academic year. That training must have been part of a program that was at least 6 months in duration and resulted in acquisition of a post-secondary Canadian educational credential, or a post-secondary foreign credential, certificate, or credential. And that training was completed within 2 years before the date on which the application was made. So I think that there's going to be some challenges with that, just because I think in terms of the specificity of the programs, I just wonder how many programs are actually going to meet these specific criteria. And also just being able to satisfy the department that these criteria have been met to their satisfaction. particularly this part about resulting in acquisition of a post-secondary Canadian educational credential. This was an issue that came up a lot with the previous program, is that even where training was completed, the equivalency to a Canadian post-secondary credential, diploma, certificate, there's a number of cases that are reported about whether or not that equivalency was established. So I anticipate some issues around that. Applicants, oddly, even though this is a direct to permanent residence program, they must nevertheless demonstrate that they have an offer of employment, which I find a little odd, because, once they have got their, first of all, we don't have any clarity on the duration of processing of these applications. One of the big concerns that arose with the prior program is that people applied with offers of employment, and at the end of the processing of about 1 year, they were issued a occupation-specific open work permit. But in a lot of cases, because the processing was so long, there were issues having to verify the ongoing nature of the job offer, because there had been such a long delay. This was mostly an issue with the home support worker type positions, just because people's care needs, they were hard to anticipate so far in advance. So we don't really know how this is going to work exactly, but what the regulations, what the instructions say is that the job offer must come from either a single employer who has a Canada Revenue Agency business, or they must come from a single employer who has a Canada Revenue Agency business number and is a private household, or a business that directly hires and remunerates the employee and controls their working conditions. So the ability of a business to be the employer of record is a new feature of this program. But there are specific conditions on this for the business, that if it's a business that recruits individuals to establish a pool of candidates who are intended to be transferred or contracted by other businesses, those groups are disqualified. So it's not intended to be used by recruiters or what are they called? Like staffing agencies. The employees would need to be directly employed by the company who's serving as the employer. There also can't be, they need to be arm's length employers. So it can't be the employer cannot be the applicant themselves. It's not self-employment, their spouse or common law partner, or a parent, grandparent, or child of the applicant. It also can't be an embassy, high commission, or consulate, or a person accredited to a mission in Canada. It cannot be one of the employers referred to in Section 200, sub 3, sub H of the regulations, which I believe is prohibited employers who have been non-compliant, and a business in which the majority of voting or ownership interests are held individually or collectively by the applicant or their spouse. The job offer must be for continuous full-time work for an indeterminate period in Canada but outside of Quebec, and it is for an occupation that corresponds with Unit Group 4410 other than a foster parent. It describes the offer must describe the applicant's main duties, which must meet with those in the lead statement for the occupation. And it must be offering a wage that is median prevailing wage if there's no collective agreement. And it needs to be genuine. And so genuineness of the offer of employment has been a factor that's gone into the assessment of applications in all the previous categories. They will be assessing, as they have in all the previous programs, whether or not the employer has a genuine need for the care that's provided. And so whether or not the offer is consistent with the employer's reasonable employment needs, and whether or not the employer is able to fulfill the terms of the job offer. They will also look at past compliance or non-compliance by that employer. So, and they've also stipulated here that the assessment of the genuineness must be based on documentation provided to the department by the employer, which is interesting because there has been some controversy about this under previous iterations of the program, where requests were made to caregivers for documentation, financial documentation belonging to the employer. So I'm actually happy to see that they've put the employer into the regulations here, or to the instructions here, because I'm hopeful that they will recognize now that they do have a requirement and a duty to engage the employer directly, because of the difficulty of caregivers trying to get that type of documentation from a prospective employer. The other element is that they must be satisfied that the worker themselves are actually intending to accept the offer of employment. So this is a challenging piece. I'm not sure how exactly that is going to be assessed or established. I tend to include a letter of intent for applicants to explain why it is that they're seeking to make this change, particularly if there's any risk or concern that the applicant might be overqualified for the position. But often it's the case that, even if they are overqualified, that they might be earning more money in Canada as a caregiver than they would in their current occupation abroad. But also, this is a new feature that they must demonstrate that they have in the form of transferable and available funds, unencumbered by debts or other financial obligations, an amount equal to 1/2 of the minimum necessary income applicable in respect of the group of persons consisting. So it's basically LICO. They need to look up what the LICO amount is and make sure that they have at least half that amount. So as I said, the provisions for the home support worker category are virtually identical, except that occupation refers to group 33102 or 44101, which is like the nurse's aide and the home support worker provisions. And the other change, the other difference, I think everything else is basically identical. The other thing that I want to point out is that there's a separate ministerial instruction that describes, and I'm switching back to that MI as well, that describes how the distribution of these approvals is going to go. The first part that they explain is that in the first year that the program runs, that they are going to issue 2,350 through online approvals in Stream A. They also hold back a certain number, which is 260 in the first year, to be submitted by alternate means. Now, in previous years, the alternate means meant that you could seek permission to submit the application on paper. It was kind of a not entirely clear process as to how that was to be done in previous years, but I did have a couple of clients who asked for permission to be able to submit the application by paper because of challenges that they were having with the portal, and they were, yes, invited to submit their application on paper. And so I don't know exactly how that's going to work, or I do, like, for sure, I anticipate that on March 31st, the program is opening at 10 a.m. Eastern time, that there will be a digital stampede, and that we are going to find that these spaces are going to go very, very quickly. So I don't know what's going to happen with these remaining 260 spots. In previous iterations of this program, those went much more slowly, but they eventually did go as well. What's important to note is that Stream B, which is the stream for applicants outside of Canada, there will be none accepted in the year 2025 to 2026. On the actual immigration website, it just says that program will be opening at a later date, but the ministerial instruction itself makes clear that it will not open at the earliest until March 31st, 2026. Thereafter, in subsequent years, they have kept it that the stream A total will be 2,475 for the year 2026 to 2027 through online means, 275 by alternate means. Oh, and again, 0 through stream B. The first time it looks like they're going to accept overseas applications is for the year beginning March 31st, 2027. And I think that that's the same. Yep, it is the same for the home support worker pilot. So the program is totally closed to outside Canada applicants during the next 2 years. What it also says is that any application that is returned based on non-compliance with Section 10, meaning that it's found to have to be missing items that will not allow it to be processed, that those applications will still be counted toward the number of applications submitted. I find this very unfortunate because we are seeing that a lot of applications are being bounced on R10, and so and oftentimes, it's for sort of technical or accidental flaws. And the issue here too is that because the program is opening at 10 a.m., right now there's no way to complete the forms on the permanent residence portal. So what I anticipate is that it will open at 10. People are going to be in a mad race to fill in the forms as quickly as possible and to submit them in order to reserve a space. But what it's then saying is that if one form, one document, a fee is not properly submitted, that application will not be accepted for filing, but it will nevertheless be counted against the number of applications for that have been used for the year. The other thing is that there's no ability to seek humanitarian and compassionate relief where that request for relief from the requirements of the ministerial instructions accompanies the application for permanent residency. So the rules must be met, and if they're not met, then the person is simply not eligible. So those are the programs in a nutshell. As promised, I will take you very quickly to the public policy. Just this one. This is the one that describes who is eligible for this public policy, this group of 140 applications for people who are out of status, or who gained their work experience without authorization. For those applicants, they must have entered Canada legally on or before December 16th, 2021, and lived in Canada continuously since then. They must also have had a work permit at some point during that period, and they must not be inadmissible for any reason other than their loss of status or unauthorized work, as well as for their family members who are accompanying them. So in these circumstances, it appears that they will be able to apply through one of these programs and then follow different steps in order to restore their status in Canada and to establish their eligibility in one of these pilots. So that's what we have to date. It's going to be a very interesting period of time. I imagine that there is going to be a fair amount of litigation. What I have found, even with the previous pilots, is that I have some issues with the standard of care that is being taken in processing of the applications. Often what I've encountered is that there is not one request for additional documents, but multiple requests for additional documents. So it's really important to be very vigilant in monitoring whatever account or email is being used being provided to the department because sometimes like if the request goes out and there's no reply on a timely basis, there's just a no forgiveness kind of a policy, which again, that's not surprising, but we've seen a lot of circumstances in which people have insisted that they never received the request for documents. Even on searching their email inbox, they haven't been able to find them. So anyways, if there are any further questions about the program, I invite you to pose them to me on LinkedIn or in the comments section on YouTube, and I will try to address them in a subsequent podcast. Thank you for watching, and I hope this was helpful.